Hi, this is Anju Devi. My student ID is 20173326. I am giving the presentation of Business Law 500 Assessment 3. I have the slides number 2, 3 and 4. Firstly, we discuss about the Wakeling versus Ripley 1951 51 SR NSW 183. Dave is a single resident of Sydney. He was a loner with poor health. He appreciated his sister Karen in Oxford, England, as well as he wished that she would come to Sydney to contribute through his care. He vowed that if she agreed, he would give her all of the possessions upon his expiry. Karen decided she quit her work, shifted at her home, as well as distanced herself from the friends. She landed in Sydney as well as immediately started caring used to her brother. Several months future, they had a disagreement. Dave's sister was disinherited after he sold his land. His sister filed a breach of contract lawsuit. Now we discuss about the Commercial Bank of Australia versus Amedio 1983 151 CLR 447 as security for the repayment of their son's business obligations. An elderly couple with limited education signed a mortgage over their property of Chatham Bank. Early their son persuaded them to believe that his farm was financially stable, while in reality it was in deep financial problems with whether the bank had the authority to exercise these mortgage guarantee rights. Lastly, we discuss about the facts about the Harris versus Digital Pulse. In the case of Brad and Jane's pizza business, they will have suffered a special loss as a result of Angie's failure to deliver and install the oven as promised. They may be able to recover damages for their losses, such as lost profits, in order to restore them to the position that would have been in had Angie's fulfilled their obligations under the contract.
My name is Aman Kumar Bishnoi. My student ID is 20173464. My topic is Case Law Harris versus Digital Plus. It is said that the case of Harris versus Digital Plus is one of the example of core concept of forcibility. This is a classic concept example of the concept of forcibility in control law. Harris versus Digital Plus highlights the importance of providing detailed information about the nature of the contract at the outset, as this can have a major impact on the parties' right if there is a breach. It also serves as a reminder that parties may only be able to recover for losses that are directly or indirectly caused by a breach, and that any losses that are considered too remote to have foreseeable will not be compensated. For example, had the original functions continued to function properly and blow out after 6 months, then any damage would be regarded as the possible because it would take such a long time. My second case law is about Victoria Laundry Limited and Newman Industries. For the same, they receive compensation and they both are allowed for other ways also. In this case, a person named Plaintiff was suffering from loss because of breach in the contract. In Victoria Laundry Limited versus Newman Industries, it was held that a plaintiff who suffers special loss because of the breach is entitled to receive compensation for that loss. It is also possible that there are remedies available to Brad and Jane, which could include terminating the contract-specific performance from NG, requiring NG to transfer the title of the goods she owns in return for full payment, ordering a reduction in price or claiming damages. There are many things which they can do to settle the case. In conclusion, the outcome is certain in the case of Brad and Jane. NG is not able to deliver the oven within the time of 24 hours. Brad and Jane must show that NG owed them a duty of care, that she breached that duty of care by failing to deliver the oven on time, and that their losses were caused as a result of breach. Additionally, they must demonstrate that the losses they suffered was reasonably foreseeable. If they can do this, they may be able to recover damages for their lost profits.
Slide number 9. Rosella Limited. Rosella Limited, a hug improprium that the deals in electronic goods distributed to a catalog to the public in which by mistake a plasma television advertisement of $2,000 got print of $200. Tom watched the catalog and thought the plasma television was very responsible price and therefore rushed to Rosella Limited to buy it. The young sales assistant informed Tom about the mistake in the printing of the price, and Tom got upset and insisted that he sell him the television for $200 for he would take the legal action. When it comes to the legal obligation between Rosella Limited and Tom, the law generally states that a contract is only valid when both parties are in agreement. There is an offer aspectness and considerations. In the case, it can be argued that the Rosella Limited did not make an offer for the plasma television at the state price. Thus, a contract does not exist. Slide number 10. Similar case, Australian Competition and Consumer Commission v Harvey Normal Holidays Limited 2011 FCA 1407. In a similar case of Australian Competition and Consumer Commission a Harvey Normal Holidays Limited 2011 FCA 1407, the court determined that the advertisement in a catalogue constituted invitation to trade rather than an offer. Australian Competition and Consumer Commission 2013. This is due to the fact that such as advertisements cannot be relied upon to be definitive or blending. As such, the advertise was merely the invitation to customers to make offers to purchase goods, which could then be accepted or rejected by the store. Therefore, in the current situation, it can be argued that the Tom's request for the television was an offer which Rosella Limited rejected and was not contractually obligated to accept. Regarding whether Rosella Limited breached the Australian Consumer Law (ACL), it can be said they have indeed done so. The ACL sets out a number of rules relating to pricing and advertising that business must be avoided by Australian Consumer Law 2010. Section 18 of the ACL states that an individual might not in a commerce or trade involve to behavior which is a defective or misleading or is a probable to the device and mislead. In the case, Rosella Limited has made a facial and misleading picture to consumer with regarding to the price of product and sell, therefore breached these rules. Therefore, Rosella Limited may be subject to penalties and the other correct measures if we found guilty of breaching and the ACL.
My name is Gurbaz and my user ID 20173540. Tort Law Case Studies. Fact: Jean versus East and Four Corner Supermarket. Jean was a steady customer at East and Four Corner Supermarket. She visited the shop once a week or often regular if their special come up. One day in the supermarket, she got tripped on grapes inside the pit food piece in gangway 3 and she fall there as well as her ankle got damaged. The store manager did not know about the situation and grabs, but there was a supply rule to clean and check the section afterward every 15 minutes. Therefore, the store manager wants to know if his supermarket repays a duty of care to Jean in addition to if he was broken any duty of care or law. Jean takes being directed to take the amount for her injury and also the expense that will occur in present and future. And for suffering the pain, approximately the total will be $1.3 million. My name is Gurbaz and my student user ID is 20173540. Case law Jean versus East and Four Corner Supermarket. The case is all about the injured customer in the Woolworths managed location by an oil spill. The facts of the current issue are identical to those in Strong versus Woolworth Limited 2012 SCA 5 when a customer was injured after slapping on an oily spill in a Woolworth managed location. Woolworth was successfully sued by the customer for a heinous act of negligence blocker 2012 when Jean slapped on the grapes in the pet food Elisa of East and Four Corner Supermarket. She suffered a serious injury that resulted in her incurring substantial damages. The question is, does the store own Jean a duty of care and have they breached that duty? When it comes to store and supermarkets, owners and operators own a duty of care to their customer to income sensible phases to avoid accidents and injuries. This includes regular checking the store for any potential hazards and damages items. In this case, East and Four Corner Supermarket has a policy of doing floor checking every 15 minutes in the fruit section, but it is unclear whether they were adhering to his policy when Jean fell. It is possible that East and Four Corners Supermarket has taken responsible steps to ensure the safety of its customers. Then gene accidents may have been avoided, such as it is likely that the store does own Gene a duty of care and may have breached the duty. The Act Gene has incurred damage of $1.3 million as a result of her accident. Future strengthens her care. Ultimately, it will be up to the court to decide if East and Four Corners supermarkets own a duty of care to Jean and if they have breached that duty. In the meantime, we can only that store owners and operators will take extra precaution when it comes to the safety of their customers. Through the incidents at East and Four Corners supermarket was unfortunate, the rest of Gulliver's tour was regularly eventful and quite enjoyable. From scenes driven along the coast to days spent exploring scenic towns, there was something for everyone on tour. The local restaurant served delicious cuisine, and the accommodation were comfortable and luxurious. All in all, it was an unforgettable experience for everyone on the trip. Part 2 Tort Law Case Studies Conclusion. After reading the whole case, it is saw that the mistake is all over of supermarket and their juniors. All the juniors of the supermarket has the super clear instructions about the color cleaning and staff should clean the floor in every 15 minutes. On the premises of supermarket, the accidents happened, and the mistake was of the store manager and his juniors, who had the instructions to clean the floor every 15 minutes, but they had failed to follow their own policy and which caused customers huge damage. The negligence of the staff and store manager should not be ignored. It is clear that East 4 Corner Supermarket does own a duty of care to its customers, including Jean. The store manager should have been aware of the potential for slappages in the greengrocery section and should have taken appropriate measures to ensure the safety of customers at that area. It is duty of the store manager to keep a regular check on the working of the staff, and if they are unable to do that, then the store manager should be made it done them. But he failed in fulfill his duty and therefore he should be changed for the negligence and difficulties faced by the customers such as it might be agreed that East and Four Corners Supermarket has breached its duty of care by failing to income practical stages to avoid spills from occurring as well as putting customer at risk. By doing the supermarket has caused Jean injury, pain, suffering, and economy losses. Given the damages that Jeans is seeking, it is important for East and Four Corners Supermarket to consider all possible options for resolution. It would be wish for them to discuss the matter with Jean and her legal term in an effort to reach an out-of-court settlement. If they are unable to come satisfactory agreement, then the civil lawsuit may be necessary. In either case, it is essential that East and Four Corners Supermarket take into account the potential cost of a court case and make a decision based on what is their best interest. Considering the relevant case of Strong Woolworth Limited 2012 SCA 5, it is clear that East and Four Corners Supermarket has been sued for the damage caused to Jean because they have breached the Tourette Act of Negligence.
Myself, Jasmine Kaur Sidhu, student ID 220173563. land with Johnny facts. It's an important debate if Anne should be required to reimburse Johnny for the harm due to his van. Facts: the question of whether Johnny should be compelled to compensate Law for the damage to his van in interesting one. The damage to the van was approximately 25,000. To decide if Johnny owns land, a duty of care, we must look at the circumstances of the case. It is clear that Johnny had a duty of care to land by parking his van in front of the garage door. He should have taken care of the land's van and should check before starting any activity. This means that Johnny should have provided land with reasonable protection from the hailstorm. Had Johnny opened his garage door and allowed land to park inside, it is likely that the damage to the van would have been avoided. Therefore, it can be argued that Johnny breached his duty of care to land by failing to open the garage door, resulting in damage to the van. If would not open the door or closed it on time, then this would not have happened. This breach like makes Johnny liable for the damage, estimated 25,000 won 2021. As such, it is likely that Johnny would be compelled to compensate land for the damage caused by the hailstorm. However, there are some arguments against this position. Firstly, Johnny could argue that he was unaware of land's presence or even his existence on the property all the times. Therefore, he did not know that about the damage to be done until after it happened. Secondly, John might argue that opening conclusion. One of the that question is that whether the Johnny breached the contract or not. It is been that the Johnny left the door of garage open. Conclusion: it is clear that Johnny did owe land of duty of case inside. He engaged him to clean his pool. The question is whether Johnny breached his duty of care. In this case, it appears that the hailstorm was an unexpected event and it would have been impossible for Johnny to have known it would occur. Had he left the garage door open for land, it would have not necessarily prevented that damage from occurring. As such, it is likely that Johnny did not breach his duty of care and should not be compelled to compensate land for the damage to his van. However, there may be exhausting circumstances that could indicate Johnny was responsible in some way. For instance, if Johnny knew that a hailstorm was possible and he still closed the door of garage door, then he could be held liable for the damages. Ultimately, the court must decide if Johnny's actions constituted a breach of his duty of care. While Sam, college friend of Polly's, gave the lift for home after the day back, she separated without thinking twice. The main components which might be merely established for the proper negligence which might be claimed are the proper duty of care, which is owned via the definite for the claimant, the damage procedure of the result. When Sam, one of the Polly's friend from college, offered her a lift from the pub after the first day back at uni, she didn't think twice about accepting it. But now, only 3 weeks later, Polly had been informed that Sam's driving license has been suspended following an incident which occurred during very same night. What exactly happened on fateful evening, and how should pay Polly feel about Sam now? This article hopes to answer these and other questions by providing some advice on how you can avoid being a similar situation, but also how to handle it for you are. In the case of Polly v. Sam, it is likely that Polly will succeed in her negligence claim against Sam. In the given case, it is clearly shown they have stopped that time, but he continued driving. There are main elements which state whether the situation is related to negligence or not. The elements that must be established for a successful negligence claim are a duty of care owned through the defendant to the claim, a breach of his duty, and damage produced as a result. It is clear that Sam owned a duty of care when driving her home. Ask a driver he had responsibly to drive with the care, attention, and take consideration of safety of his passengers.